Adjournment. At number 22. 125 or 21.
Appeal dismiss.
At number.
God bless you.
Here now, 15 of 2024.
Petition dismissed.
May I please also? With the function of the other side, I am back to mention item number 10. I am paying 10. I am paying for adjournment. My senior comes 10. 10.
Let's say, kindly may fix a date. 10.
10.
Wait.
Let's say 13, 14, 13 August.
30
Right.
office. Okay.
26th of August.
26.
26th.
Okay. That's agreed.
I don't
Let's put the person. Some is the matter of that.
Item number 3, my lord, I have filed one affidavit in
Item
objection.
number
3. That perhaps has not been checked, so may it come after a week, my lord. Or
after a week.
After a week or 2 weeks. The next date is on 24/9 before the lower court.
You inform the other side.
I will inform my lord because he is not available.
Okay. Mr. Jalal learned counsel for the respondent number 1 and 2. With consent of the other side, press for this matter. After 1 week.
Published.
May I please, Lordship, I'd like to mention item number 12, Lordship. We have taken consent from the other side, Lordship. Senior counsel, Mr. A.K. Prabhakar, had some
You are for which party?
respondents, Lordship. Respondent.
Miss, your good name?
B. Ronghanti.
Learned counsel appearing on behalf of Mr. You are appearing on behalf of
Mr. A.K. Prabhakar.
A.K. Professor, learned counsel for the respondent. Conducting counsel for the respondent with consent of the other side, press for this matter. When?
Lordship, after 1 week.
After 1 week. Fair enough. The matter after 1.
Item for according to mediation. At number 1.
Yes, so who is for the appellant? You. So do you refer the matter to the mediation?
Yes.
Can be.
Matter may be referred to the mediation update.
Pardon?
Matter may be referred to the mediation update.
Okay. Yes.
I'm for the respondent number 1.
Respondent number 1.
I am for respondent number 2, Lord.
Pardon, miss, your good name, please.
S. Chanda.
S.
Chanda.
Learned for the appellant. Mr. Sorma for respondent number
2, Lordship.
Respondent number 2 and madam.
S. D. Saikya.
Learned counsel for the respondent number
1.
This matter is listed under the column for referral to the special mediation, drive mediation for the nation. The learned counsel for both the parties understand. This matter may be referred to the mediation. Accordingly, the matter is then referred to the mediation. Principal brings the matter before the mediator, and the parties are directed to appear before the mediator, Guwahati High Court Mediation Center on understated
Date.
within 1 week.
I'm taking
18.
13th,
In August.
13.
letter number 2.
My lord, LCR received, my lord. This is the matter of contributing negligence, my lord. So this matter may be heard, my lord.
Part में L Sharma, Lord Porter, and Ms. X Porter.
Respond number 6.
6, and Mr.
T. Hussain on behalf of IATL, respondent number 1.
Respondent number 1. So, no sons.
Yes, my lord.
Your Lordship, so far as my learned friend is saying that contributing negligence, there was no evidence to that extent from the appellant side, and there was no finding of the learned member.
My lord, in
Therefore,
GD entry, my
Lordship,
lord, can you see GD entry,
There
my
is
lord?
no
in the
evidence at
record, my
all.
lord.
And Clement himself stated that the bus whom my learned friend is appearing, suddenly in the middle of the road, hard brake he applied. Therefore, the truck coming from backside, it hit.
My
How
lord,
can it be
in GD
contributory?
entry, my lord, overtake the,
And there
overtake
was
the bus, my
There
lord.
was no
Truck
evidence
is
at all.
overtake, take the
They
bus,
have
my
not
lord.
filed any evidence.
In GD
That
entry,
is
my lord, it
the-
is clearly stated, my
That
lord.
is the entire facts, Lordship. They have taken the plea.
It may be heard, my lord, at the time hearing.
It's a case of Lordship 2014 judgment, Lordship.
That may be fixed, my lord.
And accident is of 2010.
But whether this CGNP was executed,
No.
time of hearing before the tribunal.
No, Lordship. They have not filed any evidence.
My lord.
Page 4 of the issue that
Yes.
is
Exhibited before the tribunal, how this city entry, this appellate stage will help you.
It is exhibited, I think, my lord, because it is attached with the LCR copy, my lord.
Maybe it may be in the LCS, unless until it is.
no, Lordship.
Let
Did
the
not
matter may be
adduce
heard,
any-
my lord.
Did not adduce any evidence.
As early as possible, my lord, let the matter may be heard, my lord. No problem.
It's submitted at the part. That though the matter is listed under the column so and so, so there is no sense of penalty considered. And as such, the matter may be heard by this court and placed for fixing a date for hearing. Hearing according to the law. Yes.
Oh,
16th September.
oh, bless me.
Must oblige, Lordship.
24.
Another case for the appellant on court with the method after 2 weeks.
Present for hearing number 41. Letter number 4.
Substantial Wilson Incorporated. Page 6.
Page number?
Page 6. ma'am. Page 6. 7.
No, Mr. Sohan, you have filed the case before the regular civil court.
Yes.
So why should the regular civil court will consider the customary law?
Because
Hmm?
my lord, discussion is there, but no decision.
Maybe.
My lord, the question was there, but it was not decided.
No, is there any requirement that the matter should be decided as per the customary law?
My lord, if the, both the parties, my lord, conducted by customary law, then my lord, yes. Because both the parties, the Garo community, belong to
No,
Garo,
maybe,
Garo community.
but the suit was filed under the CTC.
Yes. But my lord, since my lord subject matter relating to succession,
Hmm?
succession law,
Hmm,
succession of land.
hmm.
So my lord, succession, my lord, being conducted by their customary law.
Then the
In-
matter
in-
should go to the customary court.
But my lord, in Assam or Karbi, my lord, there is no customary court.
Then why the regular civil court will follow the customary?
Yes, yes, yes.
Huh?
The one of the substantial question, other substantial question was there. The plaintiff himself stated that my lord, his father left plot of land. And there, my lord, the plaintiff side left two brothers and two sisters. 4 persons, my lord, legal here. One, my lord, filed the title suit without impleading others, other 3. In the plain, my lord, the plaintiff himself stated that we are 4 persons from our father's side. So, my lord, in absence of my lord, other 3 legal heirs, the court should not decide. My lord, plaintiff, in the plain, it is itself stated that on paragraph 3, which is at page 10. Because the right title interest of other 3 illegally are also my lord involved.
Whether any issue was framed by the trial court in this regard? Non-joiner of necessary party?
My lord, court observed, we have not raised the question. My lord, my lord, in the plain himself stated. My lord, kindly see, my lord, the paragraph 3. Death after the death of original Pattadar Mijendra Marag in the year 1989, all the property of late Mijendra Marag, including the Suitland, devolved to which legal heirs.
Paragraph number?
3, my lord, page 10. Involved in his legal heir, and they have owing possessing the same, getting cultivated every year. Subsequently, the 2012, a fresh annual patta number so and so issued in the name of legal heir Sachindra, Rofin, Pavitra, Nini. Only my lord Rofin filed the suit, and others, my lord, not even included as defendant of. That is, my lord, in essence of the other 3, my lord, court should not, I mean, cannot decide.
No, you see the last line, at present only the plaintiff is surviving as legal heir and other Pattadars died
Yes.
months ago.
Yes, this is also vital question, my lord. If it is so, my lord, he should have included the when they died and they produced the death certificate. Where, my lord, this statement will not do, my lord. Only death certificate and my lord, after death, left
Whether you
their
have
children,
Sir.
my lord.
Mr. Sohan, whether you have raised this issue before the trial court at the first appellate court?
Yes, my lord. Because, my lord, can you see, if suppose, my lord, they dead, my lord, their children are there.
Hmm.
And my lord, without prayer of confirmation of my lord, recovery of possession, decree was granted. It is also illegal, my lord.
Pardon?
Without, my lord, recovery of possession or confirmation of possession, because, my lord, plaintiff himself said that he is not in possession. other persons are in possession, defendant are possession, then my lord, recovery of possession not pray for. Can you say my lord the prayer at page 12? Prayer is for confirmation of possession. When confirmation of possession is there, if a person is in possession, then only prayer for confirmation of possession should be there.
No, if he is already in position, then why should he pray for recovery of position?
Because he himself is
Therefore, confirmation of position is there.
because my lord,
Prayer number B,
because he himself that my lord, he stated that he is not in possession.
where?
In the evidence, my lord.
Show me the evidence. Have you include the evidence with this bill?
I have not enclosed the evidence. The defendant has been in the suit land which I gave them to cultivate in one place.
Then Mr. Sohan, you do one thing, you bring on record the evidence by filing an additional affidavit. And also you produce any relevant documents in respect of this substantial question number 1. In respect of Garu customary law.
Yes.
Or Mr. Sohan, pardon me for the appellant. List the matter of it. 18th of August, so as to enable Mr.
18th.
Sohan to bring on record the evidence of the witnesses examined before the Lord at trial court by filing an additional affidavit. This recording.
Thank you, Lordship.
Yeah.
Lordship, we have filed the amended memo appeal inserting the substantial question of law before the Lordship certificate. Page 18, the substantial question of law, Lordship. May I submit now?
When this petition under order 41 rule 27 was dismissed,
It was in the appellate stage. And that was rejected by the trial court. We have approached the High Court. High Court has directed to consider the case at the time of the hearing. That has been rejected again,
prior to hearing of the appeal.
prior hearing to the appeal. And that is why we have rejected. We have filed CRP before this honorable court. In CRP, this court has directed to consider the order 41 rule petition at the time of hearing. That also rejected.
Whether that order is part of the record.
Lordship. Lordship will find at
5/2022.
page 130 is the order of this honorable court.
No, that rejection order. of
In the
the-
appellate court itself, Lordship, in the appellate judgment itself. In the appellate judgment itself, that was not considered. No separate order has been issued
When it was considered,
at the time of,
hearing the
at the time
appeal
of
or
hearing.
prior to that.
we have filed before fixing the case for hearing. That was rejected. After that, we have approached this honorable court. This court directed to consider the case at the time of hearing. Court heard the matter at the time of hearing, but rejected in the final judgment. No separate order has been issued.
Where is the finding?
Lordship will find
Page number?
at page 159. Appellate court judgment start from page 133. Now Lordship will find from 156 onward, everything has been recorded. That petition filed under order 41 rule 7, appellate court has a power to allow the document to be produced, page 156. In the judgment itself, it has been passed, recorded. No separate order has been issued,
Not necessary.
not necessary.
Now, what are the substantial question of process?
Lordship will find at page amended plain, page 18.
Have you went through the petition under order 41 of 27? Yes.
Lordship, I have annexed
Page number
page number 90,
19.
90. Three petition has been filed. Page 90 is the regarding Lordship to prove the original suit filed by them against my father, my parents, and that was dismissed. And thereafter, Lordship appeal was withdrawn without on the basis of a compromise, according to them. But there is no compromise decree. Page 92 is the regarding the exhibit 123, that is birth certificate issued by the school authority.
Where is the certificate?
Certificate Lordship will find at page 68, Lordship. 69. Original copy 69 and page 6 is type copy.
But this certificate has been exhibited.
Exhibited by the headmaster of the school. Exhibit 1.
How does the third substantial question of law involve hearing?
Lordship will find originally they have filed a suit. We have filed a petition to prove that case. Originally they have filed a suit. That is Lordship will find at page 103. Type copy is from 96. Suit was dismissed by the trial court for eviction of us from the land by judgment dated 8/6/1970. Thereafter, they have preferred appeal. Appeal was also withdrawn without any leave, and that was said that it was withdrawn on the basis of compromise. Lordship will find at page 119. 118 is the petition. Lordship is aware, Lordship, if a compromise decrees have to be passed, then there is a compromise petition, under which
Right, but whether this was the issue before the appellate court.
that was the Lordship order 41 to 27 petition has been filed to produce that evidence. That was also rejected. Page 90, Lordship, that petition.
No, your petition was rejected by the appellate court. That might be a question of law to be decided, but this issue, it was not before the learned appellate court.
The appellate court, I have filed a petition under order 41 to 27 stating that I am not aware regarding the judgment and it came to my knowledge on Iman. Lordship will find page 90 again, Lordship. Page 90, Lordship. Page 90. Lordship will find para 4. Plaintiff and pro forma defendant number 4, who are minors at the time of decree in title suit number 3587, did not know the fact of title suit number 395/68. As a result, despite of exercise of due diligence, produced such evidence when the suit, title suit 101, was heard and decided. Plaintiff appellant came to know that the fact of title suit number 395/68, October 19. Immediately thereafter, they file a petition for certified copy of the plain and WS judgment and have supplied on Iman. We want to produce that evidence that already they have filed a suit that was dismissed by the trial court.
Is page number 90 in title appeal number 35 of 2007.
Oh, Lordship. Page
90.
90 is regarding
And
Lordship.
in this second appeal is against the judgment and decree passed in title appeal number.
No,
13
Lordship.
of 2009.
This is not a fair. Originally, they have filed a suit against us for rejectment. That is title suit. Lordship will find at page
136.
136.
It was renumbered as that.
That was renumbered as 35 of title appeal number 13 of 19.
Earlier 35 of 17.
Earlier 35 of 17.
Page 136.
Page 136.
No, the present second appeal is against the judgment and decree passed in title appeal number 13.
Lordship.
Then how this title appeal number 3517 is
No, no, it's same.
Lordship will find at page 136. Page 136. 35 of 17, now title appeal number 13 of 19. Renumbered. After transfer.
page number?
136. Renumbered as 13 of 19.
Originally it was
Originally 35 of 17.
there shall be only one substantial question of law.
Lordship may record that any other subscription will claim at the time of hearing. Lordship.
The second appeal. Article 100. Read with order for note one of the code of civil law. This report by the appellate challenging the judgment that ordered it. Judgment that dictated 6/55 passed by the learned party that court in title appeal number 13 of 2019. It is to be noted here that by the judgment that dictated the learned first appellate court has affirmed the judgment that dictated 16/9/2017 passed by the learned motion number 1 title number 100. Okay. Where is the memo of appeal and the grounds mentioned therein and the suggested substantial question of law. And also where is the judgment dictated to passed by the learned first appellate court and also the judgment that dictated to passed by the learned trial court. This appeal is admitted on the following substantial question of law. Whether finding of the learned trial court as well as of the appellate court regarding minority of the appellant without consideration of the petition filed under order 41/27 can be considered as proper when minority at the relevant time was right to be established on the basis of school certificate which has been marked as exhibit 1, 2, and 3 and other documents. But is it your case that these exhibits were not considered by the courts below?
Lordship, it was not considered that it was duplicate has been issued. Certificate has been proved by the headmaster of the school. Counterfoil has not been produced. Counterfoil of the school certificate has not been produced at the time of evidence. That was the trial court finding and appellate court finding.
What wrong with that finding?
Because Lordship, counterfoil, what is the necessity of counterfoil of the certificate? Headmaster of the school has come and adduced evidence that I have issued a certificate. According to school register, he is the age. Why the counterfoil is necessary?
But there are some judgments that counterfoil has to be produced at the time of
That is why, Lordship, we have filed a petition under Order 41/2027 to bring on record the documents which trial court and appellate court did not consider. To substantiate the exhibit 1L 2, 3, we want to prove that.
the court may also consider finding of any other substantial question of law if found necessary at the time of hearing after notifying both the parties. Issue notice to the respondent, returnable and forwarding the fee taken by registered to AD and also by the process. It's also record for the learned court below is the matter of
Which paper stay of the execution of I 2380. There are two one I went to withdraw also. Because it is wrongly filed for stay of the my case also. Double to double nine. We want to withdraw that miss case. One I
number of the execution proceeding.
number of execution proceeding is 26 of 94. I number 2380.
At what stage it is pending now?
Lordship.
At what stage the proceeding is pending now?
Pending is Lordship after dismissal of the they will proceed that was stayed earlier.
No, it stayed earlier already, but now at what stage it is pending?
We are in possession of the land. We are in possession of the land. If that is
No, execution proceeding is at what stage? For report or for what?
execution proceeding, they have started in 1990 for necessary order.
Necessary or let notice to address it.
Lordship, it is fixed on 7, Lordship. It is 7. Till status quo till 7, Lordship.
No, let the other party.
Otherwise, Lordship, on 7 it is
Because
fixed.
it is for necessary order, not for report.
It is 7 fixed on 7. Status quo till date, Lordship. To 7. Otherwise, Lordship,
We are not rejecting your petition. Rejecting your prayer. Prayer will be considered on appearance of the other side of next day. If I number 2299 you want to withdraw.
we do, Lordship.
Mr. Goswami learned counsel for the applicant submits that he has the instruction to withdraw his interrogatory application. Where allowed is I is necessary to withdraw.
If Lordship, may I submit, Lordship? If it is not paid, Lordship, it will become, Lordship, infractions.
No, we are not rejecting your.
Lordship, I understand, Lordship.
Yes.
Till returnable date, Lordship. Till returnable date, please, Lordship.
It is only for necessary order,
No.
not for report,
No,
not
no.
for execution of the
I
deed.
understand, Lordship. Till returnable date, Lordship.
We'll consider on next step. It is observed in the orders.
Compliance.
My lord, as per direction of the Supreme Court, my lord, we applied for certified copy of the order dated 1/8/25, my lord, but that's yet to, my lord, yet to obtain, my lord. We have not received it till yet, my lord.
You have not received it.
Yes, ma'am, okay. We have applied on
You have
second.
applied.
Yes, ma'am,
So after 1 week then,
my lord.
after 1 week,
No, my lord, tomorrow it will be up to today itself, my lord. Today or tomorrow, my lord.
today,
Yes, ma'am.
today,
This will be obtained, the order copy, my lord, will be obtained today itself, my lord.
then tomorrow,
Tomorrow, my lord.
so Sohan learned counsel for the petitioner submits that he has already applied for the certificate copy of the order dated 1/8/2025 and will be receiving the same today itself and he will publish the same for the court file. And he price for listening the matter tomorrow.
Some problem.
Day
Day
after
after tomorrow, yes, day after
Day
tomorrow.
after.
It will be
They are-
convenient.
They allow present the party after.
Obliged.
Please, your Lordship, I'm seeking adjournment for the day because my senior is not feeling well.
Who is your senior?
Mr. S.Q. Roy,
Please go to him, please.
be there.
And his counsel will confirm from the other side present the section matter after
Lordship, we fix on Thursday as the matter is urgent.
on
This Thursday. On this Thursday as the matter is urgent.
or
Responding.
May it please your lordship. Lordship, if your lordship is convenient, any hearing on next week, lordship.
Lordship, the urgency is that the respondent is already started construction over the suit land. And they will finish casting of the roof of the first floor if it's not heard urgently.
Lordship.
On last three occasions,
we are ready to hear the matter. Even today also we are ready.
Lordship, I understand.
Sure.
Unfortunately, I have to seek adjournment today. Lordship, can it be taken on?
Both the parties places of the matter on Monday.
Lordship. Deeply obliged.
Obliged.
May please lordship. I waited for the response number 1 claimant.
Lordship, may kindly produce the Lavazima court's order.
My lord, let me, I brought it. Already, yes, the case is already negotiated for national and local laws in the month of December 2024. But 24. Yes, respondent 2 is not necessary here, owner of the vehicle, because it is already negotiated, but ultimately that was not settled because a very poor amount. During this, from January to September, when I entered into the case, then I also approached to the authority of this company. Then they come to, ultimately they come and last, they will satisfy the awarded amount. I said the minimum you give the interest, because this case is 2013 case. You file an appeal in 2023. It is why fixed for hearing. 2 is not necessary because the substantial question of law, not against the 2. Even then, evidence also I have seen, not against the 2, owner of the vehicle. It is admitted fact because once this is negotiated, although the amount is not reasonable, so question does not arise for appearance of the respondent number 2.
Mr. Paul, this matter is listed for order.
Today's order, my lord, fixed for hearing, because LCR already received. LCR to I sent.
May I submit your lordship? Lordship,
LCR
Lordship, may kindly peruse the Lavazima court's order dated 29/7/25. That is at flag number D, Lordship, the last part.
I also.
From my humble prayer will be Lordship, at least 1 week time may be granted, Lordship, to take the step. That will be my prayer, Lord. Because this is our appeal and we know the owner is an essential party in this case. Lord.
Because the substantial question is there is a no whisper regarding the owner. There is a no allegation. Even the case is fixed for, they said that it is a fit case for settle the case. If it is a fit case for the settle the case, what is the requirement of the owner? I do not know. I have that knowledge. Things is that, my lord, possibly LCR does not come. So it is from Bhojali, Commissioner Workman Compensation, Bhojali subdivision, my lord. So call for the record as soon as received.
Whether you have taken a step for causing service. of
Lordship,
notice of
actually the
arrest on
problem
number
is that when the case is listed before the Lawazima court, the Lawazima court stated that the case will be put before the honorable court. After that, you can take the step, after direction of the court. That is why we could not take the step. So 1 week time, Lordship. That is my humble prayer. Because LCI has also not come. Until then, we can take the step, Lordship.
Partner is normal or happen then the part 4 respondent number
One.
Mr. Sorma garden homes for the appellate drawing the attention of this board order dated 29/11/25 of the Lawazima court submits that that he has taken 1 week time to take step on the respondent number 2 to effect service of notice upon respondent number 2 by the state and in place for 1 week time. 1 week time. Take step and accordingly the period is allowed. This is submitted after 1 week. So Sarma said while affidavit after effecting service upon respondent number 2 by the state and this is a little reminder to the learned commissioner for
Bhojali.
getting the record.
Bhojali, my lord.
Borpeta,
Bhojali or Borpeta?
Borpeta, Lordship.
Nowadays is a Bhojali district.
Borpeta.
Borpeta. Borpeta, Bhojali, you didn't make it Bhojali. Because it is an independent workman commission. Borpeta also there, Bhojali also there.
No, which commissioner has passed the order?
Bhojali, my lord. It is
Bhojali.
Bhojali. It is had. In the judgment, it is written Bhojali. Bhojali subdivision, Borpeta. But nowadays it is a district.
Where is the order?
My lord, page 8.
Page number 8, Lordship.
Bhojali.
Because it
Bhojali
is a
subdivision, Borpeta.
because it is a case of judgment delivered in the 2014. That is the subdivision.
Take the matter after 1 week.
Lordship.
Much obliged. Much.
For hearing, item number 8.
I am for item number 9, your lordship. 8 and 9 are in fact connected. Same against the same judgment. Against the same judgment. For 8, Mr. Biswas was here.
Then we can proceed to hear the item number 9.
No problem. Again the same judgment. Lordship, otherwise the case is a new one, your lordship. The substantial questions of law were framed. The appeal item number 9 was admitted on 3 substantial questions of law. And on the previous occasion, while there was a deliberation, your lordship, first coming to the plaint, your lordship, it starts from, in item number 9, it starts from page number 7, annexure 1. The suit was filed by them. Initially, the suit was dismissed. There was a counterclaim. The counterclaim was decreed in our favor. Thereafter, in an appeal filed by them, a single appeal, there were no two separate appeals. In a single appeal, the entire judgment was reversed. So, coming to the plaint, your lordship, basically, if we come to the prayer of the plaint, which is at page number 19 onwards, they have prayed for 1/3 of the total plot of land described in Schedule A, your lordship. And Schedule A is described. However, Schedule B, C, and D are not properly described, your lordship. On the previous occasion, while there was a deliberation, I proposed a fresh substantial question of law as well, your lordship, because they filed this case for partition of the entire property, your lordship. But B, C, and D being not described properly, whether the substantial question of law that I proposed, whether a final decree could be passed by the appellate court in absence of proper description of Schedule B and Schedule C property, your lordship. Because in a partition suit, your lordship knows there has to be a preliminary decree first, which has to be then finalized by a final decree. The decree was passed by the appellate court. The suit was dismissed initially. The counterclaim was decreed. A single appeal was filed, and against that, the entire suit was dismissed, and entire suit was decreed, and the counterclaim was dismissed. Another substantial question of law that was also framed, your lordship, was for the compliance of Order 41, Rule 31. Because as the first appellate court was the final court of facts, your lordship, no doubt the court has dealt with the issues altogether. But since the facts of the case is such that there was a counterclaim which was decreed and the suit was dismissed, the appellate court, as your lordship is aware about the Zulfikar Ali judgment, your lordship, the appellate court was under a duty to frame the points of determination under such circumstances when the appeal was against, a single appeal was filed against both the decree of the counterclaim and dismissal of the entire suit. So there had to be a point of determination. Without framing any point of determination, the entire judgment was revisited. That was a substantial question of law already framed. So if your lordship hears the matter in this aspect, your lordship, I propose that this may be remanded back for non-compliance of 4131, your lordship. Otherwise, I'll start up to arguing on the.
Mr. Mukherjee, on the other day, I have pointed out about one judgment delivered by Supreme Court in the case of Adjournment Mehta versus State of Gujarat or Gujarat Municipal Corporation. There, Supreme Court will say that even if no point for determination is formulated, but there was a discussion on the issue by the learned first appellate court, then this non-framing of non-formulation of point for determination will not be fatal.
I'll have to go through that judgment as well, your lordship. But in this present case,
Mr. Chaudhary, what is your submission in respect of his submission of
No, your lordship,
framing of additional
your lordship, your lordship sees,
substantial question of law?
because this petition is not maintainable, your lordship, your lordship will see. Because here in this petition, there are no grounds. And under Order 41, your lordship, the ground, it has specified. If your lordship see his RSA, your lordship, only the question of law has been researched. Your lordship will see. Page 4. If there is specified order, I show that provision. Your lordship. The second page, 26. Your lordship. He has mentioned grounds involving substantial question of law. Your lordship. These are the question of law he has framed. That's 8. These are all substantial question of law according to him, your lordship. But none of them is there, your lordship. Page 4 to this thing. And if your lordship turn to
No, according to them, these are the grounds.
no, your lordship.
The court has framed it by an order.
Just please don't interrupt. I didn't interrupt. If your lordship to see order 41. Order 41, your lordship. Appeals from original decrees, your lordship will say. CPC. Every appeal shall be preferred in the form of memorandum signed by the appellant or his pleader and presented to courts to such appoints on behalf of the. The memorandum shall be accompanied by a copy of the judgment, provided that here is an order. Then 2 is very important. Contents of memorandum. The memorandum shall set forth concisely and under distinct heads the grounds or objection of the decree appealed from without any argument or narrative. Such grounds shall be numbered consecutively. Where an appeal is against figure, then your lordship say grounds which may be taken an appeal, your lordship. The appellant shall not, except by leave of the court, urge or hurt support any grounds or objection not set for the memorandum appeal, your lordship. But the appellate court in deciding the appeal shall not be confined to grounds or objection set for so and so. Provided, so your lordship is very clear. He has to specify the ground on the basis of.
No, Mr. Sotori,
Yes, sir.
The appeal has already been admitted.
No, appeal has been admitted ex parte, your lordship. I was given. Your lordship, it may be, but I can raise this objection. Why not? Appeal has been admitted. But question is, can the appeal is maintainable, your lordship? That can be gone into.
It is after admission, the
No,
question of maintainability.
Maintainability can be gone into what? Maintainability suit is not gone into everything. Maintainability can gone into, your lordship. Maintainability has not been closed. If I can point out the maintainability is not maintainable, how can your lordship say appeal admitted, a second appeal admitted doesn't mean that everything is correct.
No, that cannot be examined in the second appeal.
No,
Second appeal is only on the substantial question.
the substantial. I'll come to substantial question. Your lordship, here I am showing.
Whether on that point any substantial question of law was.
Which one, your lordship? I am the respondent. How can I raise a substantial question of law? It is there. I am the respondent, your lordship, not.
No, you may be respondent.
So there is no. According to there is no.
If necessary, now also we can frame it.
No, I don't have to, because I said these are all facts, finding of facts.
Admissibility cannot be open now.
Your lordship, because this may be recorded, your lordship, this object, because otherwise he cannot violate this.
No, Mr. Sotori will only hear on substantial question of.
Substantial question, your lordship will see, your lordship, I have given the judgment, your lordship, the Supreme Court judgment. What are the substantial question of how it is framed? These are now not a singular substantial question.
These have already been framed.
Your lordship, framing that, if your lordship.
Mr. Sotori, see.
You
can only submit on the point of substantial question.
Your lordship, accordingly, these are not substantial question of.
That's all right. We will hear you.
Your lordship.
First, I'll let him complete.
Let him, I'm not. He has.
This maintainability at this point cannot.
Maintainability can be raised. Maintainability can be raised anytime. Maintainability.
No.
Because if a provision is not complied, how can your lordship can say they can override or this order 41 rules?
There are several decisions. Second appeal only on substantial.
That is there. What question is if the petition is proper or not in proper form, what will be the consequences?
No.
You cannot file a petition like that, your lordship.
Yes, Mr. Mukherjee.
Worship, regarding the thing that it is not a proper appeal, memo of appeal, your lordship, the provision that my learned senior has read out is regarding appeal from original decrees, Your Lordship. This is an appeal from an appellate decree, and as such is a second appeal, Your Lordship. And that apart, the grounds involving substantial question of laws are mentioned, and not all, but 3 out of all these were framed by this honorable court. So coming to the grounds, Your Lordship, substantial question of laws that are framed. First, the facts of the case, Your Lordship. One Dhaneshwar Barua was the owner of a plot of land, Your Lordship. He had 2 sons and 1 adopted son as per them, Your Lordship. Coming to the judgment of the trial court first.
Page number.
It starts from page 41, Your Lordship. Title suit 66 2012. Annexure 4. Lordship, if Your Lordship permits me to submit, Your Lordship, because this appeal is otherwise a very new appeal, Your Lordship, recently admitted, Your Lordship. There are other old pending cases. If I may confine my submission as regards to the compliance of 4131, Your Lordship, if Your Lordship pleases, and if that is not, if Your Lordship if I can convince Your Lordship to that effect that if 41 and 31, Order 41, Rule 31 is not complied with, it has to be remanded where, I would start with that one first, Your Lordship. Because going into the merits of the case entirely, it will take a lot of time. So this page 41 is the judgment of the trial court, Your Lordship. Page 43, the plaintiff's case is stated in brief. This is a suit for declaration of right title interest, partition by metes and bounds, delivery of possession, eviction, separate possession for permanent injunction, and for permanent injunction. Late Dhaneshwar Barua was the father, namely Moheshwar Barua, Moheshwar Gogoi, late Ramakanta Gogoi, and late Pyari Mohan Barua. So Dhaneshwar Barua was the father of 3 persons: Moheshwar Barua, alias Moheshwar Gogoi, Ramakanta Barua, and Pyari Mohan Barua. The said late Moheshwar Barua, the father of the defendant number 1, had 2 sons, namely late Tankeshwar Gogoi and late Rupeshwar Gogoi. And the wife of late Rupeshwar Gogoi has also expired. Late Rupeshwar Gogoi's only son, defendant number 4, Sri Biraj Gogoi. So Dhaneshwar Barua has 3 sons: Moheshwar Gogoi, Ramakanta Barua, and Pyari Mohan. Defendant number 2 is Moheshwar Gogoi, Your Lordship, one of the sons. Defendant number 1 is the son of Moheshwar Gogoi. The defendant number 1, Uttam Gogoi, is the son of, and other 2 sons, Tankeshwar Gogoi and Rupeshwar Gogoi. That said, Tankeshwar Gogoi, son of late Moheshwar Barua, had survived by his legal, by his wife Srimati Jharna Gogoi, defendant number 3, and minor son Sriman Suman Gogoi. The minor son of defendant number 4 lives under the care and custody of his mother, and the minor shall be represented by his mother and natural guardian Srimati Jharna Gogoi. That as stated above, said late Dhaneshwar Barua left 3 branches of lineage through 3 sons, namely Moheshwar Gogoi, Ramakanta Barua, and Pyari Mohan Barua. The defendant number 1 to 5 are the heirs and successors of Moheshwar Gogoi. Defendant number 6 to 8 are the heirs and successors of late Pyari Mohan Barua. Plaintiffs are the heirs of late Ramakanta Barua. So all 3 of them are lineage to Dharmeshwar Barua. The ancestors of the plaintiffs and defendants, late Dharmeshwar Barua, owned and possessed considerable landed property, particularly acquired 3 bighas of land under DAG number 275, now covered under PP number so and so, and 1 bigha, 1 katha, 1 lesa of land under DAG number so and so, now under PP number so and so, in village number so and so. Both the land under DAG number 274 and 275 are adjacent to each other. Thus, the total plot of land 4 bigha, 1 katha, and 1 lesa is fully described in Schedule A. So there are 2 separate plots which is fully as a whole described in Schedule A. That on the death of Dhaneshwar Barua, his successor, 3 sons become entitled to all his movable and immovable properties, and more particularly Schedule A land described hereunder. That during the lifetime of Moheshwar Gogoi, let Ramakanto Borua and let Pyari Mohan Borua, all sons of Dhaneshwar Borua, agreed to divide the 4 bighas, 1 katha and 1 lesa of land described in Schedule A equally in respect of share of 1 bigha 2 katha each. It is the plaintiff's case, their case, that during the lifetime of their fathers, they agreed. Accordingly, let Moheshwar Gogoi and let Pyari Mohan Borua opted to take the northern and southern part of 1 bigha 2 katha of land respectively, leaving the middle portion of 1 bigha 2 katha of land for let Ramakanto Borua, the husband and father of plaintiff number 1 to 4. The middle portion was left for them. The middle part of 1 bigha 2 katha of land, that is 1/3 share in Schedule A land, which was mutually agreed to be the share of Ramakanto Borua, the husband and father of plaintiff number 1 to 4 was lying vacant, and the plaintiff or their husband and their father during his lifetime erected no new structures thereon. However, let Moheshwar, let Ramakanto, and let Pyari Mohan never got their respective shares in Schedule A land revenue partition, but had their names mutated in both the periodic patta number so and so of Schedule A as Ejmali Pattadars. After the death of late Moheshwar and late Ramakanto, the then surviving brothers of Pyari Mohan Borua, the defendant number 1, the then surviving son of late Moheshwar Gogoi, now dead Tankeshwar Gogoi, and the plaintiff number 3 mutually demarcated the 3 shares in the year 2004. The plaintiffs were given 1 bigha 2 katha of land in the middle of Schedule A with equal share to the defendant number 1 and other heirs of late Moheshwar Gogoi on northern side and equal share to let Pyari Mohan Borua on the southern side. Now I will take a pause here, Your Lordship. Coming to the plaint, Your Lordship, they have stated the entire Schedule A plot was a joint plot of the ancestral plot. Thereafter, they have agreed mutually to share it, to divide it into 3 parts, 1/3 each. Coming to the plaint, Your Lordship, at the schedule mentioned in the plaint, plaint starts from page 7, Your Lordship. Page 20 is the Schedule A. It is a land measuring 3 bighas and 1 bigha 1 katha 1 lesa. So total 4 bigha 1 katha 1 lesa, Your Lordship. Then, as per them, there was a 1/3 share division as Schedule B, Schedule C, and Schedule D. Schedule B, they claim to be there. Schedule B plaintiffs 1/3 share in page 21, Your Lordship. And Schedule B is simply described as land measuring 1 bigha 2 katha in Schedule A land, 1/3 share of the plaintiff. In the narrative of the plaint, they have said it is in the middle portion of the Schedule A land because that was left for them, and the other 2 sides, northern and southern side, were taken by the other 2 brothers. But this being the position of the schedule, Your Lordship, Schedule B, whether the final decree could be passed if the Schedule B was not properly demarcated, Your Lordship. That is the substantial question of law I was proposing on the last date, Your Lordship. My proposition was whether a final decree, this is the partition suit Your Lordship has seen, Your Lordship, whether a final decree could be passed by the appellate court in absence of the proper demarcation of Schedule B and Schedule C land. Schedule C, they are stating it is under illegal and excess possession of possession of defendant number 1. So Schedule A is the entire land. Which portion is under excess possession?
Schedule B, C, and D are part of Schedule A
A land.
Yes.
They have paid for partition.
And Schedule A land is described. Yes. Boundary is described.
Total boundary is described, Your Lordship.
Yes.
But there is no dispute to Schedule A land. Now, within Schedule A land, there were 3 brothers and their lineages claim that this 1/3 portion is mine. We have agreed mutually, our ancestors have agreed mutually to give me the middle portion. So these subsequent schedules will have a separate boundary of their own. Which side will be the other brothers, which side will be the other. Simply stating 1/3 of the Schedule A, Schedule B is described as 1 bigha 2 katha 1/3 share of plaintiff. Which portion that is not described here? It has to be seen whether a final decree could be passed on the basis of such a description in the schedule, Your Lordship. Because first there has to be a preliminary decree. A preliminary decree has to be finalized thereafter in case of partition suit. That is why I proposed a substantial question of law and it is framed, your lordship, they will get sufficient chance to revert to that substantial question of law as well. Apart from the 3 substantial question of law that I have already posed and had been framed by this honorable court. If it is framed today, so maybe for the hearing they will get some chance to rebut against that as well, as per the decisions of the Supreme Court. Arguing the entire thing on merit will have to take.
Partition is also only in respect of schedule A land.
Yes, schedule. So if they are claiming.
Preliminary decree is passed in respect of schedule A land.
Yes, your lordship. But the decree here is a final decree, your lordship. That is under challenge. A final decree could not have been directly passed, your lordship, in a partition suit without there being a preliminary decree.
Oh, I don't think there is any necessity of framing any other substantial.
Lordship, in that case, the first substantial question of law that is framed, your lordship. Coming by this one, your lordship. First, they have prayed for partition. Their partition suit was dismissed. There was a counterclaim by the defendant stating that we have acquired right through adverse possession because since the time of the ancestors, your lordship, they have left the property and never turned back to the property. We have been all throughout in possession of the entire property. So adverse possessory right, we have acquired adverse possessory right in terms of section 27 of the Limitation Act, since they have not claimed their right title interest over the property for so long, and that counterclaim was decreed in our favor. Against that, your lordship, they have preferred one single appeal. And in the appeal, your lordship, their suit was decreed and the counterclaim was dismissed. In the last part of that appellate judgment, your lordship, appeal is allowed on contest. Judgment and decree dated so and so passed by the learned Munship number 2 in Tezpur is set aside. Prepare a decree accordingly. Now coming to the peculiar situation here. Here, since there was a suit and a counterclaim, your lordship, ideally there ought to have been 2 appeals, your lordship. But since it was heard in a single appeal, relying on the judgment of this honorable court in Zulfikar Ali's case, your lordship, I may. It is reported in 2022 1 GLT 434. As the first appellate court is a final court of facts, your lordship, coming to parent number 18 of the judgment.
Oh, that is well settled.
Yes, your lordship.
There is no dispute on that one.
No, lordship.
Then why you are referring to this?
Lordship, in term for order 41 rule 31 compliance, your lordship. Because on the other day, lordship has even a judgment of the, there was a judgment of the Supreme Court as well.
Hmm.
However, in the peculiar facts and circumstances of this court, this case, Your Lordship,
Hmm.
because there was a
Hmm.
dismissal of the suit and decree of the counterclaim. Against that, a single appeal has been filed, preferred. The appeal is allowed. So while allowing the appeal, if I read para 18, Your Lordship, of this judgment. Because here the appellate court is first appellate court is the final court of facts. Though it has discussed the issues, it is not the trial court that it will discuss the issues plenarily by overlooking the findings of and comparing the finding of the trial court again and discussing the evidence as a whole. Before doing that, the appellate court has the right to do so. But before doing that, appellate court has to be satisfied under what context all the issues are being rediscussed and reread. And the mandate of law under Order 41, Rule 31 is that the appellate court has to come and come out with a point of determination as to why this judgment of the trial court is bad in law. Thereafter, we'll go and discuss all the issues altogether. The appellate court did not formulate any point of determination. Without formulating any point of determination, if the appellate court goes on directly to all the issues, rereading all the issues.
Sir,
Lordship.
Mr. Mukherjee,
Lordship.
I am referring this judgment. Mugendro, Indravan, Mehta and others versus Ahmedabad Municipal Corporation. Civil appeal number 16,956.
Civil appeal number, Your Lordship. A citation is there?
This is a direct judgment from the court.
No, the citation is there. No,
Citation is not there, but it is.
CA number?
Number is there.
CA number is what, Your Lordship?
Civil appeal number 16,956.
16,956.
Dash 16,957 of 2017.
2017. Name of the case, Your Lordship?
Mugendro,
Govindra.
Mugendro.
Mugendro.
MRUDENDRA, Mugendro, Indravan, Mehta and others versus Ahmedabad Municipal Corporation.
Lordship, may I know the date of decision? Well,
Yes.
fine.
CA number is 16956-57, Your Lordship.
Yeah.
Of 2017.
Okay. Lordship, in that case, I'll have to go through this one as well, Your Lordship, to apprise your
Oh, we'll take it up at 2 p.m. then.
Lordship.
2 p.m.
The lordship, have it on Thursday to a day after tomorrow, that will be better because
You want to go through it?
day after. Day after tomorrow?
Heard Mr. Mukherjee, learned in item number 9.
Both 8 and 9 done together, yeah. They have to come together.
Okay, day after tomorrow, then
Both 8 and 9. Keep them.
like that.
Because the Gujarati names are very tough. Gujarati names are very tough, very long. Deep level.
Well, in this case, I am appearing on behalf of Mr. D. Chaudhary. My name is not there in this case. He is in court number 2 and the matter will take some time. May I pray, my lord, this matter will be taken up next Tuesday, my lord. Well, I have taken the consent, my lord. My colleague.
Okay, Mr.
I am appearing on behalf of D.
Your
Chaudhary. D. Chakraborty.
T. Chakraborty, learned appearing on behalf of Mr.
D. Chaudhary.
T. Chaudhary, learned consulting from the appellant
Yes, my lord.
with consent from the other side. That's for the Tuesday.
Tuesday, next Tuesday, my lord, 12th of
Yeah.
August. I am deeply obliged, my lord.
My lord, I am appealing for both in both the cases for the respondents.
Note to put. হ্যাঁ, more note to put. কাগজগুলো সব উল্টা করে দেয়। Lordship grants me a moment. I'll get my papers. Lordship takes up item 14 first. This second appeal is directed against the judgment and order dated 3/5/2017, refusing cancellation of a sale deed dated 29/3/1978, purportedly executed in favor of the respondent by the predecessor in interest of the appellants, who passed away on 7/4/1998. On the ground that the requirement of Section 90 of the Evidence Act is met with, as the sale deed is more than 30 years old. The substantial question of law was framed by this Honorable Court on 11/6/2018. And it reads as, whether the finding of the learned court below to the effect that the sale deed dated 29/3/78 was more than 22 years old and therefore a presumption under Section 90 of the Evidence Act 1872 would be drawn in its favor is vitiated by perversity. Well, before I draw your lordship's attention to the judgment, but on the face of it, the sale deed is dated 29/3/1978. The suit was filed in the year 2000. It could not have been more than 30 years old. The sale deed was 22 years old. And that sale deed would have to be proved like any other document. Proving was relied upon, that it was proved was relied upon because of the fact that somebody, an independent witness, had merely said that moi a sakkho to chini pao. That wouldn't be enough, my lord. The document would have to be proved. That was not done. Aside from that, my lord, on 14/6/2000, my lord, title suit 49 of 2000 was filed by the appellant as the plaintiff. This was a suit for cancellation of the sale deed executed by the predecessor in interest, purportedly on 29/3/78, in the interest of the declaration that the sale deed is void. My lord, this is at pages 16 to 25 of your lordship's brief. My lord, the prayer.
This annexer one.
Yes, my lord, annexure 1.
Is that type of
Beg your lordship's pardon.
page number 16?
Yes, my lord,
Page
it
number
begins
6, Page number 6.
16, my lord. Begins at page 16, lordship.
That is the original copy.
Yes, my lord.
This is type copy.
Type copy, type.
Page number 6. Page number 6.
Yes, my lord. Yes. Yes. 6 is the type of, indeed, my lord. Prayer is at page, my lord, here in page 14 of your lordship's brief. Declaration that the sale deed dated 29/3/1978 in favor of the defendant and allegedly executed by late Abdul Rahim, the predecessor in interest of the plaintiffs herein, is a fraudulent, invalid cancellation. Second, cancellation of mutation. Well, this is the suit. Well, the judgment of the trial court, Malad, at pages 42. Second, more Nijor Sutru. Pages 42 to 43. The operative part Malad, of the judgment impugned. This is the trial court judgment.
Yes.
Page 41, my lord, if I may draw your lordship's attention to third paragraph from top.
Yes.
DW1 Abdur Rahman, the predecessor in interest of the defendants, my lord, stated in his evidence that he purchased the suit land from Abdul Rahim by sale deed dated 29/3/1978, took possession, got mutated. D1 also has stated land is mutated in his name. He has been paying the said revenue, land revenue. D1 also stated he rented the house over the suit land and he received it. DW1 has stated that Abdul Rahim was at Dibrugarh. DW1 has also stated that he did not issue notice to the plaintiffs in the mutation. This is, my lord, very crucial. Well, then again, at page 42 of your lordship's brief, may I read it out? The last paragraph. Here in this case, the plaintiffs have stated that Abdul Rahim did not execute the sale deed and it is a forgery one. But the plaintiffs have done nothing to prove it was rather Sukhamay Mozumdar, PW3, has admitted in his evidence that the signature on the sale deed is of Abdul Rahim, the father of the plaintiffs. Well, here I stop for a moment. He's not an attesting witness. Well, then the father, PW2 Pul Begum, the tenant of the plaintiffs, has also stated that she paid house rent from 89 to 96. But the plaintiffs have failed to prove that Pul Begum was asked to pay to rent to Abdur Rahman by Abdul Rahim for realization of debt. No documentary evidence is given by the plaintiffs. Plaintiffs' side have stated in their PW1 that they do not know the holding number of suit land. Rather, the defendant side had exhibited the municipality tax receipts. Exhibit. So municipal tax receipt is evidence of possession, the next line. That possession can only be decided by the settlement officer in the under rule regulation 41 of the land revenue regulation. So the document had to be proved. It was not proved. Mere signature. On that, my lord, the suit came to be dismissed against us. And my lord, the judgment impugned, the appellate court judgment. I draw your lordship's attention to pages 97 to 99.
Madam, we will resume after 5 minutes.
Lordship. May it please your lordship.
Yes.
Well, we were in the appellate court's judgment. If I may draw your lordship's attention to pages 97 to 99 of your lordship's brief. Paragraph 10.9, 98, madam. Before that, madam. 98, madam. Paragraph 10.9. Plaintiffs did not bring any of the official witnesses from the office of the sub-registrar or from the circle office or from the Dibrugarh Municipal Board. to show that the registration or mutation or corrections were done without following the procedure established by law. The defendant could not produce any such evidence to rebut the presumption on the sale deed. In the absence of any such proof, in my considered view, the document which is more than 30 years old cannot be held as a forged one. Well, this is the anomaly in the judgment. The document was 22 years old at the time of the suit. When the suit was filed, it was not more than 30 years old. Well, this goes to the root. And again, my lord, at 11.1 down below, my lord, page 98. On perusal of the evidence, it appears that PW3, Sri Sukhamani Mozumdar, in his affidavit, in his evidence, identified the signature of Abdul Rahim in the sale deed as Exhibit Core 1. Identification on the sale deed by an independent witness is sufficient to comply with the requirement of Section 67. On a document which is, my lord, here, more than 30 years old, again, my lord. Here, I again submit, my lord, the mere registration of the document is also not enough. My lord, to that, I seek to support my arguments, I seek to place reliance on, my lord, AIR 1972, Assam and Nagaland 15. I will make a summary of submissions and give all the judgments I rely upon, my lord, by tomorrow. Paragraph 6 of the judgment, my lord. Paragraph 6. Good. I am good. Well, lord, may I read it out, my lord? It is, however, well settled, left-hand column, my lord, page 17, paragraph 6. It is, however, well settled that when an execution of a document is being challenged, the certificate of registration alone will not be sufficient proof of due execution of the document. Registration alone does not dispense with the necessity of proof of execution when the same is denied. It is true that a sale deed is not required by law to be attested. Even then, proof of execution of a sale deed when it is denied will have to be furnished, as in the case of any other document under Section 67 of the Act. Evidence side. Then I seek to place reliance on AIR 1979, Guwahati 68, paragraph 9 thereof, my lord. Paragraph 9, my lord, on the right-hand column, line number 1, 2, 3, 4, 5, 6, 7, 8, 9 from bottom. More than a mere admission of a signature is needed to amount to admission of execution of a document. My lord, and if the error is of such a magnitude that it goes to the root of the matter, it becomes a substantial question. My lord, that I seek to place reliance on AI 1988, SC 1858. Goodness gracious. 88, SC 1858, paragraph 5, page 1860. The court is under a duty to examine the entire relevant evidence on record, and if it refuses to consider important evidence having direct bearing on the disputed issue, and the error which arises is of such a magnitude that it gives birth to a substantial question. Here it says 30 years old, the document was merely 22 years old. It would have to be proved. That goes to the root of the matter, my lord. And my lord, value of mutation entries, my lord, here the reliance is placed on municipal tax receipts. But even I can go and pay the municipal tax of any building. that is not proof of possession or ownership for that matter, my lord. What the Honorable Supreme Court says on municipal tax entries, my lord. I couldn't lay my hands on municipal tax entries, but on mutation entries, my lord. 1997, 7 SCC 137. Paragraph 21 thereof.
What is the page number?
1997, 7 SCC 137. Paragraph 21 thereof, my lord.
That is regarding this mention.
Mutation entries, my lord. The value of mutation entries. 137. Yes, my lord. Paragraph 21 thereof. Relying on a case, Swarani case, my lord, it says, relying on 1996 SCC 223, quoting paragraph 7 thereof, mutation of a property in the revenue record does not create or extinguish title, nor has it any presumptive value on title. It only enables the person in whose favor mutation is ordered to pay the land revenue in question. It does not create any right. That is mutation entry. My lord, here it is municipal tax receipts being the basis of possession. That, in my humble submission, cannot withstand scrutiny of this honorable court. And the judgment impugned both of the trial court and the learned first appellate court are liable to be struck down. That's my humble submission. I'll make available the entire judgments and my written summary of submissions tomorrow, my lord, along with all the judgments. Obliged.
In both the matter?
Both the matters, my lord. Kul Begum is the, in item number 13, she is the tenant of the appellants in item number 14. She was sought to be evicted when she came and filed a suit, and thereafter we filed a suit. Both the suits, all the 4 suits, both the suits were dismissed, both the appeals were dismissed.
Yes.
Mr. R.P. Sharma is appearing in this case, but he is in another court, your lordship.
All right. Or after some time.
At 2.
At 2 p.m. Excellent.
Second judgment, take or up.
Yeah, please, your lordship. The engaged counsel is taking up a hearing matter in some other court. Can it be taken at 2, lordship?
At 2, we have which 2 matters today?
As third item, lordship, at 2. As third item at 2.
Third item.
Then lordship, it may be on day after tomorrow or any other convenient date to your lordship. Otherwise, I am ready, lordship. I am in the RSA.
But we don't know how much time they will take in 2 matters.
Lordship. The convenient date.
Day after tomorrow then.
As per at 2, lordship, day after tomorrow, pick time, lordship.
Okay.
If possible, lordship.
Okay. As agreed by learned advocate of both sides, that's a matter Thursday at 2 p.m.
Obliged, lordship.
Item 17, I was informed that the petitioner's counsel is not available today in station. Senior counsel, Mr. B.D. So they were, my lord, supposed to mention, but then I don't see anybody around.
None appears for the appellant. Mr. B. One, 3.
Hello.
1, 2, 3. This is the matter after 1 week. This is the 2019 matter.
This was once heard and put in CAV and then it had to be
Really?
released.
How many times?
Once, my lord.
1. But it. Okay, we'll try it on.
My lord. And between,
Provided
in between, I think bench one was taken up by Justice Borua, so he cannot take up the matter, so could not have been listed, man. Apply.
May I please, Your Lordship? This matter is supposed to be argued by Senior Counsel Z. Kamar. However, he is in court number 6 in another matter. May a date be fixed or may an adjournment be given by this court?
You first go through the record and you tell me how many adjournments you have taken on this ground.
My lord.
Okay, we'll grant you adjournment, but you have to pay some cost. How much you were ready to pay? 10,000?
My lord, if Your Lordship permits me, I'll go and contact him once.
Okay.
Okay.
We have used Your Lordship. Your Lordship, finally the matter may be passed over for the day.
Lordship, finally the matter may be taken because it's an old pending matter, Lordship. It has come for the hearing first time.
Your Lordship, the engaged counsel is not present today.
Who is the
S. Roy for insurance company, Lordship, respondent number 1.
Lordship, we fix a date, Lordship, if possible.
or
B. Hajarica on behalf of S. Roy,
That's right.
respondent number 1. Lordship.
Out of state.
Yes, Lordship.
After 1 week.
Lordship, after 1 week, if a date is fixed, Lordship. Oblige, Lordship.
Obliged, Lordship.
I'm from respondent. This is appeal and they filed petition for divorce that was rejected by, and several dates they have taken adjournment. Today,
Now that is for the line of Mr. Porua. And computer is present. There is the matter. After 1 week, in the event of something that not represented of the appropriate to the.
obliged.
I had seen the party,
Yes, Lordship.
but after some time.
Last item.
At 2 p.m.
Please, Your Lordship, my lord, I'm extremely sorry I could not be on time, my lord, with all respect, my lord. My lord, please give me a last chance, my lord. On the next day, either 21 or 22, my lord, I'll do it, my lord. I undertake it to do it. Because actually I have prepared certain CBI matters, my lord, in the meantime.
So, I think today you have taken 7 adjournments.
My lord, earlier there was, my lord, I do appreciate, my lord. Yes, my lord, actually, I'm having all my briefs, my lord. But to please,
prior to that, you have taken many adjournments.
my lord, only one last chance, your lordship will kindly reflect it in the order sheet and give a preferable date on 21 or 22. I'll definitely do it, my lord.
Or, that was and also part of on the pair which made by the Kamar.
Okay. 21st. Much obliged, my lord. I'll do it, my lord. Both the matters, my lord. Much obliged.
30 and 40.
Right, please, Your Lordship, I apologize for interfering in between. Your Lordship, my matter was item number 17, and while it was I was at the other court and I was looking at the
Which matter?
item number 17. I was looking at the display, it was showing 14 and 15.
The operative is 26 of
Yes, but the order reflects non-appearance. I was just I was misguided by the display.
that order is
P. Soren.
third at
P.
2
Soren.
p.m. Yes.
Hello.
Before going to the facts of the case, my lord, I think facts will not be so much relevant in the sense there must be very substantial question of law that is fixed in this case. Lord, so I'll come to the order dated 11/6/2018, where this court fixed the substantial question of law, my lord, on the submission made by the appellant.
Yes.
In both the cases, my lord, the question is same. Whether the finding of the learned court below to the effect that the sale deed dated 29/3/78 was more than 22 years old and therefore a presumption or section 90 of the ABC Act 1872 would be drawn in its favor is vitiated by perversity. Now, my lord, here what my lord, suit was filed on 2000. Document was my lord 1978. 78. The register deed in K1 was of 78. So it is only my lord 22 years. So there is no question of 30 years, my lord, only 30 years beyond would come under section 19 of the Evidence Act, as lots of knows. Then it will carry.
The survey was executed in 1978.
78. And that was not challenged also. And their cell deed, so-called cell deeds were not proved also. So they said they have challenged that anyway. Even if they have challenged it, it was not 30 years old. On the date the suit was filed. Suit is of my lord 2000. So once the substantial question of law fails, my lord, in a second appeal, on the section 100 of the CPC, then the appeal is not meant to do. That's what the Supreme Court, plethora of judgments of the Supreme Court are there. The intent and, my lord, the purpose, as always, the procedure fixed by the legislature is to be followed. My lord, there is this Gurudev Court's judgment, my lord, of 2006. So, referring many about dozen of cases in here, it said, my lord, citation is very difficult, the online system. Gurudev Kaur and others.
The citation.
They call another online. Tumukot. SL. The reporter SLP is civil 20797 or 2003.
Yeah. 715.
Oh, sorry. 2007 1 SCC 546 my lord. AIR is 2006 AIR Supreme Court 1975. Here my lord. The Honorable Supreme Court is the very first sentence my lord. The lordship judges must administer law according to the provisions of law. It is the bounded duty of judges to discern legislative intention in the process of adjudication. Justice administered according to individuals' whims, desire, inclination, and notion of justice would lead to confusion, disorder, and chaos. Indiscriminate and frequent interference under Section 100 in CPC, in which cases are totally devoid of any substantial question of law, is not only against the legislative intention but also the main cause of huge pendency of second appeals in the high courts, leading to the colossal delay in the administration of justice in civil cases in our country. So the substance question here, the very formulation of the substance question was, the formulation was wrong. It was on the basis of submission made by the other side.
No. This substantial question is framed.
Yes.
What is your submission on?
This substantial question is my lord. This would not help the appellant to even go on merit of the case, because here the document was never 30 years old. Section 90 says beyond 30 years. Then it will have different evidence value. If it is not, then why is the question of this substantial question of law? Even the substantial question is noted is 22 years old. Yes.
It was filed in the year
2000. GS number. I'm giving
so
right now.
according to you, this section 90 of the evidence like not coming.
No, not at all. Evidence check, please. It's 90 madam.
No, but this question is framed on the point of perversity of the finding.
Yes. What about here? Since the trial court, it was not at all stated anything. In the appeal, my lord, it was not stated by them also. But the learned appellate judge upheld the judgment of the trial court. But this point was just brought in, my lord. Interesting. You are also going to see appellate judgment starts at page 63.
Yes.
They'll also going to come to page 84, my lord, directly. Before that, my lord, you also may come to page 83, then 84. First, discussion and reasons thereof. I have heard Mr. So. Yeah. From the pleadings and contention of the defendant, appellant, it has come to light that the defendant disputed the plaintiff as the owner of the or landlord of the premises in which she has been residing. This was the tenancy case. We had filed the tenancy case against the so-called tenant who was my tenant but claimed to be in collision with them, claimed to be their tenant.
Number of
Number is my lord this 376. Main case.
একটু আগে করেছে মোর তো একটু মোর একটু আগে একটু is the কোনটু করেছে
Oh, this everything.
একটু item 14 আগে item item 13 আগে this is the tenant
Tenant.
একটা ফাইন্ডিং দুটোই আগে করে আপনি করো
So my lord, paragraph 11. From the findings and contention of the defendant appellant, it has come to the light that the defendant disputed the plaintiff is the owner of the or landlord in respect of the premises on which she has been residing. According to her, Abdul Rahim, since he is the landlord and on his death, his legal heirs are the present landlords. Therefore, let us analyze the materials to decide this point at the first. On perusal of the exhibit co, which is the original sale deed number 1094 dated 29/3/1978, by virtue of which Abdul Rahim this is sold out the plot of land measuring 2 bigger 26.76 center, covered by dog number so and so, situated Kaburu, Pathar Ward, Dibrugad town, Moja, along with 2 sheltered houses measuring 50 by 17 to the original 20. The aforesaid sale deed was duly registered before the sub-register at the Dibrugad as on date filing of so and so. The document was of about 32 years. It took 22 years. This one.
paragraph 11 too also my lord
Yes.
got it next page
Yes, next page.
more than 30 years ago
Next page. Admittedly, 84, page 84. Admit the document is of more than 30 years old. The defendant did not produce any material to show that the said document was not a genuine one. The defendant did not examine the officials of the defendant was other side. Now they are appellant here. We are the plaintiff in this case. We want to evict the tenant. There is a cross case, my lord. The defendant did not examine the officials of sub-register or any other officer in this regard to show that the document was not duly registered. In the absence of anything contrary to the aforesaid sale deed, its execution is presumed to have been done in a valid manner. The defendant's side did not produce anything to but rebut the presumption. So this document, our document was, they could not dismantle it. But document is not of 30 years or 32 years. It was only 22 years. In place 32, 22, it was in 30.
You cannot derive the benefit of section 9.
Yes. They cannot derive. They cannot derive. So this was not the fact, my lord. Even issues frame, my lord, in the trial suit also, my lord. So kindly come to issues.
But we have to confine ourselves only to the substantive.
Yes, yes, that's my thing. Whether this substantial question was framed valid in terms of the facts and fact situation of the case. It was not. Apparently not. On record not. So we cannot go beyond the record. And lots of kindly come to issues.
No,
Yes.
necessarily we can frame additional substantive
My lord,
after notifying both the parties at the time of hearing.
my lord, if your lordship wants to frame a additional issue, then I'll go on that.
You examine the matter and you submit the court whether there is an
No, I think there is no necessity. Because both the courts finding, concurrent finding of the only that the appellate court just added, I don't know where from, with what mind, he added the 32 years. Otherwise, there is nothing. It's totally concurrent finding. They could not, in the trial court, it was not argued. Even in the issues framed, it was not there. It has come out of the blue. Perhaps you are thinking of 32 years, 30 years, then it should be document 70, 1970. And then also it will be beyond 30 years. That the document must cross 30 years, not on the dot 30 in section 19. More than 30 years old. That is what the law says. And what's my learned friend argued my lord, that mutation, all this will not come second appeal. The facts part is gone. Now it is totally on the legal point, the second appeal my lord, should be founded. And primarily founded in the subsequent question of law. What section understands? Second appeal. Save as otherwise expressly provided in the body of this code or by any other law for the timing in force. An appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves substantial question of law. So, my lord, your lordship will first satisfy, my lord, that there is a good and forceful substantial question of law. Certainly, the appeal will be entertained. Although the factual part, what my learner argued for about an hour, very lengthy argument, CD, without, but that would not have. In this case, this is also about 8 years, almost 8 years old appeal matter, and suit is of 2000. Both the suit. Our suit was earlier in time and number matter. Their suit was subsequently filed against us. But they could not prove anything, my lord. They could not prove any iota of their right that is interest of the land. Nor their claim that they had purchased the land in 72. That document, my lord, that document was exhibit. Amar to prove it. We have proved, but they could not prove their document. So they claim that, without proving, my lord, that they had purchased the land in 72. But their document remained properly unexhibited and unproved. They sold the land to us. They sold the land to us. And their document is remained unchallenged. They could not dismantle it. Their document, they claimed to have been purchased in 72 from other parties. That was neither properly exhibited nor it was proved. The court's finding is that our document is genuine and our purchase was genuine. So if our purchase is genuine, then we are the landlord. So this lady who now in collusion with the so-called landowner, who are the appellants in both the cases here, Full Begum, he was playing foul, and that is gone. If we are the owner legally, through our purchase, then this lady is our tenant. So she needs to be evicted. In this case, there is 376. And in other case, my lord, then filed by them against us. 376 was filed by us against the said Full Begum. Facts are same, my lord. In both the appeals, both the trial court judgment, same facts, same judgment. Here in my lord 144 of 2018, this appeal, RSH 144, my lord. We filed a suit against them, my lord, on 8/3/2000. Our suit number was 27 of 2000. And they filed the suit against us, my lord, on 14/6/2000. We filed in March and they filed in June. Their suit number was 49 of 2000. Same year, but ours was earlier. Your lordship may kindly see the plaint also. Their plaint, there is no pleading at all on this question. There is no issue framed. Trial judgment also, there was no plea at all taken by them. In the appellate court also, they had not taken a force. But the Lord judge, I don't know how he brought in this fact, this issue, section 90. Meanwhile, their Gurudev judgment, 2007, this is that I have shown. But in there, my lord, I'll also kindly come to the page 11 of the judgment, my lord. Last paragraph, there is the paragraphing also in this case, in this judgment. The observation of the page number 11, my lord. You'll also kindly come to the first, second, third, fourth, fifth paragraph. There is no numbering of paragraph. This court again reminded the High Court in Commissioner Hindu Relations that the High Court has no jurisdiction to in second appeal to interfere with the finding of fact. Second paragraph. Again, this court in case of State of Kerala versus Mohammed Kunhi, 2005, has reiterated the same principle that the High Court is not justified in interfering with the concurrent findings of the fact. This court observed that in doing so, the High Court has gone beyond the scope of section 100 of the Code of Civil Procedure. Yeah, last one. Again, in the case of Madhavan Nair versus Bhaskar Pillai, it is of 2005. This court observed that the High Court was not justified in interfering with the concurrent findings of the fact. This court observed that it is well settled that even if the first appellate court commits an error in recording finding of fact, there itself will not be ground for the High Court to upset the same. Nothing. Okay.
Okay.
So, Malad, this is my case.
Yes, Madam, any reply?
Well, this substantial question of law was framed on that 30-year issue. That finding in both the judgments, items 13 and 14, that goes to the root of the matter. Why is the sale deed valid? Because it is more than 30 years. That warrants interference by the Supreme Court. That alone is enough for setting aside that judgment. It's bad in law, Miller. That's my humble submission. I've placed the judgments. Obliged. Of course, Miller, I dare not make any comment about the capabilities of my senior colleague. He did make one, of course.
In this case, so Malad, in my submission, there is no further scope to frame any additional question of law also. Now, that ends. In concurrent finding, Malad, hardly any scope to interfere. All right, man.
Sir, you tell me whether the of the sale deed was approved.
There is no. Ours were approved.
No, Miller, it's just the signature. The judgments are very clear. It's just the signature.
No, it is finding.
No.
Finding out in both the cases, finding out. The lordship may go through with both the judgment.
I will place Miller. Signature,
Because
Miller.
it is their duty to prove it. They were the plaintiffs challenging our sale deed. They could not do it. That's what they find. Both the courts find it. Found.
Page 42, item 14. Third paragraph. Line number 3 from top. The bottom, the last paragraph. Rather, PW3, page number 42 of your lordship's brief, item 14. Item 14 to no really.
Page number
42. Has your lordship got it?
Yes.
Line number 3 from top, the last paragraph. Rather, PW3, Sukhomoy Mozumdar has admitted in his evidence that the signature on the sale deed is off. It is not the document, madam. And Malad, further below is very telling. Defendant side has exhibited the municipal tax receipts. They show the possession of the defendant. We are still in possession, madam, today.
Is your written argument or only the judgment?
Well, my lord, the judgments, but the written arguments, my lord, tomorrow I'll place.
Pardon, sir.
I will. Deeply obliged.
Or
Abraham.
That third seat was part of the record. Yep.
What did I call for the record? It is CTNT, the fact sheet was not there. They stated the fact sheet in the court.
The third seat, the record was in the court.
Yes, sir.
Whether it was a photo. The case was a photo.
So,
We have called for the record.
yes, sir. Last, last
First is the part of the MSC. First it has been filed in the case, MSC. Yes, that is there.
The question is in the city entry, the vehicle number is 68,510.
10.
But in the third state, it is as 98,0349.
Yes.
How the number is set by the IO?
First, if I had gone to the scanned copy, if I may, if Lordship,
Yes.
I could find Lordship, everyone can make a mistake. Even that police official who had gone to the spot, who had made these GD entries, 4510, even if he has made a mistake, there must be some way to rectify that mistake. On 7th night, 7th July 2015, the police officials had gone to the spot. They found that as per GD entry, I'm reading it from the GD entry. They found that in the meantime, the people have sent the two injured persons per day. One is the rider of the motorcycle, the other is the bicyclist, the deceased in this case. They were sent to hospital and they found one cycle and one motorcycle lying there on the spot. And as per their language, motorcycle con mechanical porikha bhabe thanale loi aha hoy. Logote cycle con ana hoy. And named the injured person Thapar Brahma, who is the rider, and Bhupesh Das is the deceased. Their names are there in the GDN. So that was 7th night, Lordship. In the meantime, Lordship, I presume, Lordship, they must have also prepared that forwarding sheet to the requisition for the MVI report.
No, FBI has examined the.
Yes, Lordship. Page 8 or the scan copy, Lordship. Page 8. Lordship may see, I don't know, maybe the original will reveal more here. It's just a layman's hunch, Lordship. It appears to be an overwriting of the motorcycle. Now, Lordship may see page 8 under the heading description of the vehicle.
Page 8.
Page 8 of the scan copy, Lordship. Maybe the original will give a better impression.
Scan copy, where it is available?
That scan copy I could find in the record. PSK record. PSK, Lordship. I could see a scan copy. Case record লগতে আছিলে আমাৰ case high court. And the original also may also be there in the record. I could see the scan copy.
Oh, wait.
Yes, Lordship, I have seen it. এইদিকে মই যিটো চাইছিলো তাতে আছে ওটা কল করে কি করুন
Criminal court or record to actually. There is a ultimate call for the record of the criminal court, Lordship, in last occasion.
There I have
Call for fire.
yes,
It is there.
In this scan copy file, Lordship, the main document GD entry is not there. I went to that GD entry itself is not there. But it has been quoted in all documents, GD entry number 330E. 330.
No, no, original GD entry is before the court.
Yes, Lordship. I also have a copy of it. But in that scan copy, where the police proceeded here, all the notes were made.
No,
There is not there. But Lordship may come to page 8.
No, Mr. Goswami, after 42 days,
FIR was lost.
FIR was logged by Joydeep Das,
Son of the
son of the deceased. In that FIR, he has mentioned the vehicle as
Yes.
AS98.
I understand that he might have collected information, he has given it. But even in the police station itself, Lordship, this tag here would show. On the very next day, Lordship, they must have come to understand this is not that vehicle, other vehicle. Fine, fair. If they are very active policemen, they have immediately found out the vehicle they have seized is not a vehicle which has caused the accident, but some other vehicle. My only point is that in some cases, because GD entry is supposed to be such a sacrosanct document, it hasn't given its due importance in the 5 judge constitutional bench judgment of Lolita Kumari. Lordship. GD entry is also starting, it can be starting point for an investigation. GD or FIR, whichever comes first. So I have a copy of the year. I'll give it to you. But Lordship, on 9th, Lordship, that page 8 is a requisition to the MBI. That flag, Lordship, I have put a flag there. I put a flag there. Page number 8. One flag data say I page 8 and a page. Let me see. The very next day, I think that was prepared immediately after, Lordship. Seizing the vehicle from at the police station and sending it for MBI. So you may see the vehicle number, everything is in very light tear print. That vehicle number is in double. It appears to be overwriting. It's my humble Lordship. I'm a little. It requires a final look into. My eyesight is a little defective in a case, so that's a reality. I have a defective eyesight. I may be wrong. And the very next day, they have changed it. Without any, I have gone through the entire, I have gone through all the notes, Lordship, in this short time. But I have not mentioned one statement where they have said, no, we are wrong in seizing that vehicle, and actually this is the vehicle that's it. Straightly start as if this is the vehicle they had seized. Existence of 330, except for quoting the number, is totally denied altogether. The contents are denied. It's not, it doesn't exist on paper in that record. The rider remains the same, the injured persons remain the same. The logical question that arises, Lordship, how could another vehicle have been found there if that was not the vehicle which was involved in the accident? Some logical explanation connection should be there. That is my only. That raises my suspicion. They are fine. They can come to Lordship that conclusion. I don't mind. But as a layman also, I'm entitled to some yellow. So how could this send overnight? Things move so fast that next day itself they change their equation. Seized one vehicle as per GD entry and send a equation on the very next day. Did not probably check it twice whether they were right or not. They should have checked that other vehicle, the report of the other vehicle should also have been there. 451. That is missing from the records altogether. That not even the entire scan copy that's in 4510 is not even mentioned once.
The FIR was filed by Joydeep Das. Joydeep Das is the claimant of this. Where he got this number? where he got the vehicle number?
Oh, that, the FIR lordship. Subject, I have the honor to inform that on so and so, my father so and so was coming from so and so market to so and so registered with driving by its driver in most cars and so and so. Back on the, he has mentioned that the vehicle was involved in the accident. And so far delay is concerned, that has been explained that they were busy with the
It is the number of the vehicle he has mentioned here.
yes.
Where he got the number?
Oh, that
You obtain instruction.
that part lordship. Otherwise, I have some submission lordship. In the event, my submission made by my friend is assumed to be true. In that event, what was the duty of the insurance company to do against the informant, police, who are alleged to be colluded?
If this vehicle
My lord,
AS 19A0349
my lord.
is insured with them, if that vehicle has not committed the accident, then how liability can be passed upon?
Yes, that is there. My question is that in the event, my friend's argument is assumed to be true. Honorable Supreme Court says that in that event, they could have to assail the FIR, charge sheet, or they have to make the complaint against the police officer who were involved with such an incident. So that has not been done.
Maybe. Yeah, the CD entry, original CD entry indicates that the vehicle number is AS 16A4510. That is the passing point of
That aspect has already been lordship he has clarified in his evidence. That is DW1, your lordship will find. That is the
before the tribunal.
yes, lordship. That is your lordship will find at page 11 in the record. He has stated that on assumption that that vehicle was involved, he picked up that vehicle. Subsequently,
DW2.
lordship, DW2.
Page number?
Page lordship, DW2, page 12. 1, 2. Okay, got it.
Oh, it like that he brought the vehicle
Yes.
what is that?
Presumption that that vehicle was involved in the accident.
The vehicle was lying there. He picked up and brought it to the police station.
Lying there, that is there, but
Where the question of assumption arises.
my lord, That part, Lordship, perhaps, my lord, my submission is that he has explained that on the presumption that vehicle was taken up.
Whether this explanation is acceptable,
Maybe, Lordship,
maybe how?
may take up a vehicle and subsequent, because at that moment, Lordship, the people were crowded in that place because 2 persons died in that incident. So they were busy with them. And some vehicle may, Lordship, may lying on that situation. And he has picked up. And later on that he has came to know that this is a not vehicle, that vehicle, another vehicle was involved in that case. Accordingly, that was sent for MBA report. Well, they may have the good case in that aspect, but subsequent duty that was Lordship as laid down by the Honorable Supreme Court, that they have not done. So in that event, that documents, Lordship, cannot be discarded and rendered as unbelievable. And one, Lordship, eye evidences was there.
Sir, the guidance of vehicle,
Yes,
the motorcycle was implicated as party.
Yes, Lord. Rabra Brahma.
Apara.
Yes, the rider remains the same. It's only in respect of vehicle that the whosoever rides the vehicle, that vehicle is injured. That is my concern. Rider remains the same. He was injured and he had to go to hospital.
Madam, can you do one thing? Can you obtain background? Who is the owner of the vehicle? That vehicle, the part ticket.
451.
5-1.
Yes.
And one evidence that the eyewitness, that evidence your Lordship may kindly look into. That is the PW2, page 7. Perhaps the informant has come to know from that.
PW2.
Yes.
Page number 7.
Yes, page number 7.
Yeah.
Paragraph 1. I am the eyewitness of this instant claim. As such, I am well acquainted with the facts and circumstances of the case. I am quite competent to swear this affidavit under rule so and so, so and so. So on 7/7/2015 at so and so, I was on my way towards my home and I reached near Ram Mandir BG colony on main road under Bongaiga PS. In the meantime, all of a sudden, the vehicle bearing number so and so 30349 motorcycle Hero Glamour coming from opposite direction in rash and negligent manner knocked down the deceased from the backside, who was in his bicycle, as a result of which the deceased sustained severe head injuries and in other parts of his body. Later, I came to know that he expired due to the said incident, and the deceased Bhupesh Chandra Das was serving as peon of so and so school, so and so. And close party, your Lordship will find in an. May I read, Lordship?
Yes.
ঘটনাৰ সময়ত মই বিপৰীত দিশৰ পৰা মটৰ চাইকেলেৰে আহি আছিলোঁ। মোৰ সন্মুখত এক্সিডেণ্টটো হৈছিল। মই 4-5 মিটাৰ আঁতৰৰ পৰা ঘটনা দেখিছিলোঁ। মই জখমীক ডাক্তৰখানা লৈ যোৱা নাই। এইটো সত্য নহয় যে বিজি কলনীৰ ৰাস্তাটো আন্ধাৰ হৈ থাকে। এইটো সত্য নহয় যে মই ভালদৰে এক্সিডেণ্টটো দেখা নাই। এইটো নহয় যে মই এক্সিডেণ্টটো দেখা নাই আৰু গাড়ীৰ নম্বৰো মন কৰা নাই। পুলিচে মোক সোধপোছ কৰা নাই। এইটো সত্য নহয় যে মই ঘটনা দেখা নাই পুলিচে মোক সোধপোছ কৰা নাই। এইটো সত্য নহয় যে এক্সিডেণ্ট কৰা গাড়ীখনৰ নম্বৰ so and so. So his part is very clear, Lordship, that he was the eyewitness, he saw the incident and he adduced the evidence. No second, Lordship, that was no rebuttal evidence against this. Well, just I am, Lordship, relying on judgment. Your Lordship may kindly say, I have relying 5 judgment. One of the important judgment, that is number 1, your Lordship may kindly see. Imam. My Lord, first citation, my Lord, paragraph 12 and 13, I will take for your Lordship, to your Lordship, regarding the fact of that case. In that case that was the allegation that a vehicle was implanted and there was some pollution. It will be noticed that, Lordship, para 12. It will be noticed that one of the police of the insurance company was that there was a contributory negligence. Even the insurance company did not dispute the factum of accident and the factum of death of the deceased so and so. The only dispute is about involvement of the track bearing number so and so, on which the MSCT found that there was adequate evidence to show its involvement in the accident. Thereafter, MSCT, after applying appropriate multiple, what was compensated. The insurance company filed an appeal before the High Court. The 2 grounds that were raised were about the denial of the involvement of the track bearing number so and so, and the fact that deceased was so and so is, and that the multiplier so and so. Now, your Lordship may kindly come to paragraph 19. Except for a bare assertion that the vehicle has been wrongly involved, the insurance company which has set up a plea of pollution has done nothing to make good its case. We find that judgment of the High Court is wholly untenable. We say so for the following reason. My Lord, tribunal has awarded, High Court has reversed that, against that appeal was filed. Now, firstly, out of these 2 reasons, it is well settled that in claim cases, in case the accident is disputed, or in the involvement of the vehicle concerned is put in the issue, the claimant is only expected to prove the same on a preponderance of probability and not beyond reasonable doubt. Some citation has been relying, and your Lordship may skip that, and your Lordship may kindly come to directly para 21. Second reason. Applying the test of preponderance of probability, we find that claimant have established their case that it was the track bearing number so and so was involved in the said accident with car bearing number so and so wherein the deceased was traveling. We say for the following reason: the accident occurred on so and so and the FIR loss on so and so, clearly giving the date, time, and the place where the accident happened. It was also mentioned that it was an unknown truck which came from behind in high speed and hit the car, as at that point the claimants were unaware of the number of the truck. It referred to the injury suffered by the deceased. Now, Lordship, subpara C, the claimant have explained the delay by clearing, stating that after the death they took time to regroup themselves and set about investigation and collecting information about the accident. Now, Lordship, may skip this some point, and your Lordship may kindly come to paragraph H, small h, page 17. The insurance company examined so and so who admitted that till the date of his deposition, no information or complaint was given to the senior police officer stating that an attempt is being made by the claimant and the owner and driver of the vehicle to wrongly include the vehicle bearing number so and so in that case. The witness also admitted that no step to cancel the investigation of the police has been taken and no inquiry has been done into the veracity of the claim. The MSCT on appreciation of the overall conspectus, particularly the impressed by the fact that the insurance company did not lodge any complaint of collusion and about the involvement of the truck in an illegal manner, concluded that it was truck bearing registration number so and so who is with the car bearing number.
The present is the FIR was filed after 40.
2 days. Yes.
40. And
I will come to that also, Lordship. I have another judgment I have given that on. That regarding delay, Lordship, in case of such fatal accident, my Lord.
there is doubt about the same. But they have taken a consistent step that this take not back.
Yes.
The criminal
Yes, in this case also, we have consistently, Lordship.
merely because they have not filed a complaint before this. They have
Yes, that's why, Lordship, the court, honorable court saying that there should be a complaint against the superintendent of police. Lordship,
let us first ascertain the vehicle numbers, so whether any vehicle existed on that day, that number. We'll hear you.
my Lord.
Since they have raised the issue, we have to adjudicate.
Yes.
Lordship, only on 9th of this month, July, Lord, a SIT has been formed by the government of Assam only for this motor accident. Plus, in compliance with an order of the Supreme Court, in the case of Safiq Ahmed, which has been disposed of 16/4/25. Unfortunately, Lordship, I could not get in stock. But subsequent to the order of the Supreme Court on 16th April 2025, in the case of Safiq Ahmed, Lordship, in this Safiq Ahmed case, a direction was issued from the Supreme Court to all high courts, all DGPs, etc., to forward a list of all such doubtful cases. And as per that, some SITs has been considered in some states like UP, etc., because Supreme Court was of the opinion that these irregularities are not probably confined to a few districts of Uttar Pradesh. It must be throughout the Uttar Pradesh and must be throughout the country. Accordingly, even our High Court was also sent a. So this has been finally disposed, and Ministry of Transport was also involved in it. Everyone, all concerned were tagged into that particular. And this is disposed of. I've got only mobile notification. I've got a notification, but I could not get it. On 16th April, next time I'll bring a copy of that. Safiq Ahmed, ICSN versus ICSN.
Let us ascertain the vehicle.
These are very important facts. Let them do it.
Mr. Argusami,
I am for one and two.
One and four.
Five.
Five. Article part. Please the matter on verdict. Immediately after immediately after and in the meantime, it is provided that for that is for district transport officer going out.
Yes, sir. Number 2 is 4510 district.
In respect
but
of
the
the motorcycle.
AS 16A.
Or AS 16A.
4510.
Dash 4.10. And also applicant has put the owner of the aforementioned motorcycle.
Well, two motorcycle, one is 16A, another is 19A. So I think there are two different districts over there. Vehicle numbers perhaps, Lordship, two different districts. Because AS 16A and AS 19A is may not be in Bongaigaon.
Can be found out from the district commission.
They can get the information perhaps now.
Yeah, transport department.
Yes.
Or we will with the transport department.
That can be done. They'll be able to give you a concrete information. Don't you clear like
Also, you adopt the track of the plan. Take that up. What you must.
Obliged.
As part.
Obliged.